Right. The next case that we look at, the Garrett case, deals with an application of the Burney congruence and proportionality test. Hopefully, it adds a little bit of clarity, although it's still a difficult case to understand, I think, largely because of the intersection with the substantive Fourth Amendment issues. So Burney, to understand that case, we had to know a little free exercise clause doctrine. And here, for the Garrett case, we're going to have to know a little equal protection doctrine. So the Americans with Disabilities Act, it has various titles. This case here only deals with one title, and that's Title I, which prohibits discrimination in employment because of disability. One of the important features of the statute that's important for the court's reasoning here is what counts as discrimination under the statute. So the statute says that failing to make reasonable accommodations in the workplace constitutes discrimination under the statute. So in other words, if a business were to say we don't want to hire someone because they're in a wheelchair and we don't have any wheelchair accessible areas of the workplace, and if it's reasonable for them to put in a ramp and they fail to put in a ramp, that would be discrimination under the statute. So the Act itself applies to all employers, including states as employers. So if this is one of those statutes that prohibits discrimination amongst both private employers as well as state employers. And we've seen cases like that. Our focus, when we've looked at those sorts of cases, has been the Commerce Clause. And then the statute also permits the recovery of money damages against employers who violate the Act. Now, most of the regulations of employment that we've seen, we've looked at the Fair Labor Standards Act, the National Labor Relations Act. These statutes we've looked at when they've been subjected to Commerce Clause challenges, because Congress has most clearly relied on its Commerce Clause. And certainly with this Title I provision of the ADA, which is regulating employment, clearly Congress could justify this entirely under its Commerce Clause power as well. So why focus then on Section 5 of the 14th Amendment? Why not do something like the Heart of Atlanta Motel case or the Katzenbach versus McClung case and focus on the easier of the two powers under which to sustain the law? Well, if you look at the statute here, and just skipping ahead a moment to the top of page 986, we see a quotation from the statute where Congress is waiving the state's sovereign immunity. So Title I says a state shall not be immune under the 11th Amendment to the Constitution of the United States from an action in a federal or state court of competent jurisdiction for violation of this chapter. So Congress wants to waive the state's sovereign immunity from suit should they violate the requirements of Title I of the ADA. And in this case, this is a consolidated case, two different state employees are seeking damages against the state. Thus, we would need a waiver of sovereign immunity in order to proceed with these damages claims. And therefore, the question becomes, is this a valid Section 5 piece of legislation? Because as we know, if it was only a Article 1, Section 8, in other words, a Commerce Clause piece of legislation, then the waiver of sovereign immunity would be no good, and the source of authority for that would be the Seminole Tribe case. So because this is a suit against a state for money damages, we need a justification for the statute pursuant to one of the Reconstruction amendments. And Congress said that this was an exercise of its Section 5 power, so therefore we move on to determine whether this was in fact a valid exercise of Congress's Section 5 powers. So the opinion is broken up into several parts here. We have part 1 on page 985, part 2 on page 987, and then the beginning of a very long analysis section on page 988. So let's look at each of these sections separately. So first, some background principles, principles that should be familiar from yesterday's class or from earlier week's classes. So this case, we see the value of last week's material on the 11th Amendment, and this case really presents the intersection of the 14th and the 11th Amendment. So we know from last week, and the court reminds us of this at the top of page 986, that first full paragraph. When Congress wants to abrogate a state's sovereign immunity, the court tells us it must do two things. It must both unequivocally intend to do so. So in other words, we need a clear statement of the intent to abrogate states' immunity. The court won't assume through implication that that was Congress's intent. And but we see here the sentence that I just read where Congress is crystal clear about its intent here. And then the second thing is that Congress must act pursuant to a valid grant of constitutional authority. So that's the Section 5 question. So what does the 14th Amendment, Section 5, permit Congress to do? Well, we know from last week's case, Fitzpatrick versus Bitzer, that it allows Congress to waive a state's sovereign immunity. And we know from yesterday, and the court will emphasize this again today at the bottom of page 986, that Section 5 permits Congress to remedy and deter violations of substantive rights by prohibiting a somewhat broader swath of conduct, including that which is not itself forbidden by the amendment's text. So, in the name of enforcing the prohibitions contained in Section 1, and in the name of prohibiting states from violating due process rights or violating equal protection rights, Congress can regulate or prohibit conduct that goes beyond those prohibitions in the name of preventing the states from doing that as a preventative measure, a proactive measure. And the statute, even if it covers conduct that's broader than the amendment's textual prohibitions themselves, the statute will be upheld so long as it exhibits congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. So this is what we learned from the Bernie case itself, that any valid Section 5 piece of legislation is going to have to meet this new means-ends test called congruence and proportionality. Remember on the slides yesterday, I pointed out to you that earlier in the court's history, I think in the 1980s, there was the City of Rome case, which said that Section 5 should essentially be read as a necessary and proper clause. So you have to think back to Chief Justice Marshall's McCulloch opinion, right? Let the ends be legitimate and any means which are appropriate should be upheld by the court. And that's how the court interpreted Section 5 in the 80s. This seems to be, this Bernie standard, congruence and proportionality, seems to be tightening the court's grips around around Congress's power, and we'll see how that works itself out here in this case. All right, so those are the background principles, the black letter points of law. Now, part 2 of the opinion over on page 987, this is where we have to do a little remediation of our own here in coming up to speed on the equal protection issue. So Section 2 is where the court sets out the law of the 14th Amendment. So if Section 5 allows Congress to pass legislation that is going to remedy or prevent states from violating Section 1, which contains the Equal Protection Clause. Right? So if Congress is going to stop states from unconstitutionally discriminating, then we have to know what is prohibited. What does it mean to unconstitutionally discriminate via the Equal Protection Clause? And so we need to know a little Equal Protection Clause law here. So one of the important points to understand is that the Supreme Court, in developing its Equal Protection Clause jurisprudence, has divided the jurisprudence up into 3 classes. So each class is going to be associated with a different identity group, and each class is also going to be associated with a different standard of review. So this is how the usual division goes. There are suspect classes, most famously race, but this would also include national origin and, in most cases, citizenship. These, if you're in the suspect class category, the state is almost never going to be able to successfully argue that legislation that so discriminates is going to be constitutional, because the state would have to pass strict scrutiny. The state's justifications would have to meet strict scrutiny. This was a version of what we discussed yesterday in Bernie, that the state would have to show a compelling governmental interest in order to have the Supreme Court uphold a law that discriminated based on race. And that's almost always impossible for the state to do. So suspect classes get the most protection from the court. Suspect classes are the hardest for states to discriminate against. Then there's this intermediate grouping, which the court calls semi-suspect classes, and these are things like sex, so discrimination against men or women in favor of the other, or legitimacy. You can't be discriminated against because of illegitimacy without the state having to go through intermediate scrutiny. So here, the state will have to do more work in justifying its discriminatory statute if it discriminates based on, let's say, sex. But not as much work. The justifications don't have to be as compelling as if the state was discriminating against one of those suspect classes. And then at the bottom, we have what the court calls non-suspect classes, and this really includes everything else. So age would be included in a non-suspect class, but importantly for our purposes here in understanding Garrett, the court held in a case called Claiborne in 1985 that disability was a non-suspect class. So if you're in a non-suspect class, that means that the state can engage in discrimination against such classes upon a mere articulation of a rational basis. So with the suspect and semi-suspect classes, the burden shifts to the state, and the state must justify the discrimination. But if it's a non-suspect class that's being discriminated against by state legislation, then the burden is on the private party challenging the state statute. The burden is not on the state, and the private party would have to show that the state lacked a rational basis. As we said yesterday, it's almost going to be impossible, not completely impossible, but very, very unlikely for someone to be able to show that a state acted without any reason whatsoever, without any rational basis. Right. Likewise, but on the flip side, it would be impossible, nearly impossible, not fully impossible, but very difficult for the state to show that there is a compelling reason to engage in race discrimination. All right. So here, the Americans with Disabilities Act, it's protecting people from being discriminated in the workplace because of a disability. But it's central to understand this case to appreciate that the Equal Protection Clause does not consider disability to be a suspect or a semi-suspect classification. And thus, under equal protection law, under the law of the Constitution, a state can discriminate against disability upon a mere showing of a rational basis. And I shouldn't say that's not quite precise. The state doesn't have to show rational basis, but the challenger would have to defeat a rational basis argument. Right, so just to summarize what I just said, the more suspect a classification is, the harder it's going to be for the state to justify discriminating against members of that class. Right? So to take another example, a state will have an easy time denying a driver's license to a blind person. They don't have to give anything other than a rational basis. If let's say a person challenges the statute, the person would have to argue that there was no rational basis for the denial, but it's clear what the rational basis would be. A court would assume the argument for the state. right? That you need to be able to be visually capable in order to drive, and that's enough of an argument. On the other hand, if the state tried to deny a driver's license to someone because of race, the state would have a virtually impossible time meeting the strict scrutiny standard. Right? Another important point, and we see the parallel between this case and the Bernie case. One thing that the court wants to make sure doesn't happen is that Congress doesn't try to undo the court's own substantive interpretations of what's prohibited by Section 1 of the 14th Amendment in the Equal Protection Clause by or in the name of passing a Section 5 piece of legislation. So this would be the confusion between enforcement and interpretation. Right? Congress is limited to enforcing the provisions of the Equal Protection Clause, but Congress cannot reinterpret the Equal Protection Clause in a way that is in tension with how the court itself has interpreted the Equal Protection Clause. Right. So this congruence and proportionality test that we looked at from the Bernie case itself, I'm going to borrow for this class some diagrams that come from the Glanning Guide to Constitutional Law. I've recommended it to some of you who visited me during office hours when we used to be able to interact. The Glanning Guide, you have access to it through the library's website. It's one of the Walters Kluwer books. It's primarily focuses on multiple choice type questions, but I think it had some good diagrams here. So the first set of diagrams in their attempt to explain the congruence and proportionality test are these. So when we talk about congruence, think about the linkage between the alleged constitutional violation and the remedy that Congress uses to combat that alleged violation. Right? So Congress should be able to articulate what problem exists, what constitutional violation exists that the statute is trying to remedy. Right? And how do they do that? Well, they should be able to demonstrate it by some of these ways listed here. There should be a legislative record documenting widespread and persistent, Garrett will mention that phrase, widespread and persistent instances of constitutional violation. Right? So in identifying the wrong to be remedied, the court here in Garrett seems to require a lot of Congress. There must be a well-supported legislative record, and we'll look at how this gets applied in this case in just a moment. So that's congruence. What about proportionality? Proportionality deals with the scope of the remedy designed. So congruence, let's assume that we find a problem and we understand the theory, at least, of how the statute is supposed to remedy the problem. Proportionality now looks more closely at the statute to see if the statutory remedy is in fact designed to address the wrong. So as the diagram says here, the remedy must be responsive to and disposed to prevent the constitutional violation. It can't be too broad. If it's too broad, like the RFRA was in Bernie, then the court says that the remedy is out of proportion to the constitutional wrong. All right. So part 3 is where the analysis begins, where the test gets applied. So going over to page 988 and thinking about that congruence question about identifying the wrong and then coming up with a piece of legislation that is supposed to address that wrong. So what is the wrong here? Is there, as the court asks in the very first sentence of part 3, is there evidence of a history and pattern of unconstitutional employment discrimination by the states against the disabled? The court goes on to say in that same paragraph, the legislative record of the ADA, however, simply fails to show that Congress did in fact identify a pattern of irrational state discrimination in employment against the disabled. Notice the constitutionally significant word in that sentence. It is irrational. because disability discrimination is a non-suspect, because the disabled are a non-suspect class, the state can get away with disability discrimination without violating the Constitution unless that discrimination is irrational. So you have to appreciate how the substantive law gets worked into the test that Congress must pass to have valid legislation here. So what is in the record then? When Justice Rehnquist, when the Chief Justice goes through the record, what does or doesn't he see? What does or doesn't the court credit in justifying or not justifying Congress's ability to pass this statute? So Rehnquist says that most of the examples of disability discrimination that are in the record are not instances of discrimination by states as employers. Instead, he says there's a lot of examples of disability discrimination, but they might be by private parties or the state acting in a different capacity other than as employer. So a lot of the record simply doesn't help to further the argument that there is this widespread pattern of states engaging in irrational disability discrimination when they're acting as employers. Then, if we look at the second paragraph on page 989, the briefs contained in this case listed more examples of state discrimination. So what about those examples there? Well, Rehnquist says that the examples there aren't necessarily constitutional violations. So let's look at the examples there. They cite half a dozen examples from the record that involve states. A department head at the University of North Carolina refused to hire an applicant for the position of health administrator because he was blind. Similarly, a student at a state university in South Dakota was denied an opportunity to practice teach because the dean at the time was convinced that blind people could not teach in public schools. A microfilmer at the Kansas Department of Transportation was fired because he had epilepsy. Deaf workers at the University of Oklahoma were paid a lower salary than those who could hear, and Indiana State Personnel Office informed a woman with a concealed disability that she should not disclose it if she wished to obtain employment. So one of the problems here is that Rehnquist says it's not at all clear that any of these things were unconstitutional discriminations. That is, there's no evidence that any of these instances, assuming that they're all true, that any of these instances actually violated the Equal Protection Clause. Why is that not obvious from simply stating what happened? Well, you have to go back to the law of the Equal Protection Clause. The state can discriminate against the disabled so long as they have a rational basis for doing so. So it looks like Rehnquist is reading each of those examples and saying to himself, I could imagine the state giving a reason for doing the things that they're alleged to have done. So the University of North Carolina refused to hire an applicant for a position of health administrator because he was blind. Well, maybe that department had no need for maybe they had no braille that would have allowed him to do his work. Maybe they served no blind individuals, and so the person wouldn't have been that much use to them. Maybe it would have cost them a lot of money to bring their building up to date such that it could accommodate such a person. All of those things would be rational reasons, as opposed to reasons based just in pure animosity. We don't like blind people, and therefore we don't hire them. No, Rehnquist is thinking the state could have had its reasons, and so long as the state has its reasons that aren't merely animus-based, then there is no constitutional violation. So raising these examples doesn't actually help the argument that there is widespread discrimination that Congress is then entitled to remedy under its Section 5 powers. But Rehnquist says even if these were even if these 6 instances were examples of unconstitutional discrimination, he says in the next paragraph, they fall far short of even suggesting the pattern of unconstitutional discrimination of which Section 5 legislation must be based. Right? So why is that the case? Why are 6 instances not enough? And then Rehnquist gives some details about just general statistics. 43 million Americans have one or more physical or mental disabilities. In 1990, the states alone employed more than 4.5 million people. It's telling, we think, that given these large numbers, Congress assembled only such minimal evidence of unconstitutional state discrimination in employment against the disabled. In other words, these handful of examples aren't enough to prove a pattern. So why are the examples invalid? I more or less explained this to you in terms of the constitutional background, right? At most, they show adverse treatment, maybe disparate treatment based on disability, but that in and of itself doesn't violate the Constitution, according to the Claiborne case. And moreover, on the next page, page 990, so there's this argument, and in part that's the court is trying to respond to Justice Breyer. If you'll note, Justice Breyer attached an Appendix C to his dissenting opinion, which is not included in the casebook here. But as I understand it, it was about 30 pages worth of examples from the congressional legislative record of instances of discrimination. Now, the court says that not all of these were examples of discrimination that were done by the states acting as employers. But one of Justice Breyer's points in his dissenting opinion is that there is evidence of widespread discrimination throughout society generally. And I think, as he says in his dissenting opinion, the excerpt that we have here, Congress could assume that there's no reason to think that the states were somehow exempt or the states somehow didn't partake in this widespread discrimination. And therefore, Congress could conclude, because there is widespread societal discrimination against the disabled, we want to include the states as employers in our prohibitions here. But Rehnquist says that Congress doesn't actually say that, and he doesn't want to let Justice Breyer make that argument or that assumption on behalf of Congress. In fact, over on page 990, Rehnquist quotes both the House and the Senate conclusions, and let's look at them in the middle of the page there. So quoting from the House report, discrimination still persists in such critical areas as employment in the private sector, public accommodations, public services, transportation, and telecommunications, and the other report says basically the same thing. So one of Rehnquist's points is that Congress focused, according to its own conclusions, on, or they thought that the evidence they had amassed showed that there was a problem of discrimination in employment in the private sector, and then other public areas, but not public employment. And so therefore, Rehnquist is able to conclude that Congress didn't try to make some argument through a long inferential chain of reasoning. All right, so really then the conclusion here is that there isn't any particular problem that Congress really even has a reason to come up with a piece of legislation to address. So you might think that the analysis ends there, and by and large, it really does. But if we move on to the next paragraph, right, and so this is sort of the assuming that everything we said was the opposite, right? Even if it were possible to squeeze out of these examples a pattern of unconstitutional discrimination by the states, the rights and remedies created by the ADA against the states would still raise the same sort of concerns as to congruence and proportionality as were found in the city of Bernie. So here, I'm going to focus on the idea of proportionality. Again, the court still has not clearly separated these ideas, but in the literature, in the treatises, I think this distinction that I'm giving here is generally well supported. So the idea of proportionality then is about seeing whether or not the remedies are closely tied to the alleged wrongs. Remember, the proportionality problem in RFRA was that every single piece of state legislation, every state action was subject to the substantial burden test that RFRA set out. right? And the court said that that was way too sweeping of a remedial piece of legislation. So here, what does the court say about the narrowness or the proportionality of the statute? Well, the court says that the specific requirements of Title I here are attempting to remedy things that really aren't constitutional violations. So the reasonable accommodation prong that I mentioned on the first slide, right? It's, according to the statute, it's discriminatory conduct to fail to make reasonable accommodations. But the court here says that this requirement of reasonable accommodation goes beyond what's required by the Constitution, which is a mere rational basis for treating someone differently because of a disability. So not hiring someone in a wheelchair because you're located on the second floor and there is no wheelchair access to the second floor, that's a rational basis for the decision. But the statute would make you put in a ramp if it was quote unquote reasonable. But that's more than the Constitution's Equal Protection Clause requires. So if that's a supposed remedy for discrimination, it's going far beyond what the Constitution requires. And then there is a defense that you don't have to provide the reasonable accommodation. You don't have to put in the ramp if this would cause an undue burden. But under the statute, it's the employer's responsibility to show that the accommodation would be an undue burden on the employer. And the court says this shifts the burden from the private party to the state. And under rational basis review, which is all that is required by the Constitution, the burden lies with the private party. So this burden shifting, again, the court says, is far more than is required by the Constitution. Now, this particular analysis here gets criticized by Justice Breyer in his dissent because he says, we've always held that Section 5 legislation can go beyond what's prohibited under Section 1. And I mentioned that in one of the slides in the, I think it's the second slide there where we're looking at the background information. And the court itself says that's one of the governing principles. So why is this out of proportion? And I think the best understanding is really that congruence is the biggest problem here. Just the fact that the majority really doesn't see any violation whatsoever going on here, and therefore any remedy is going to seem out of proportion. The way to see the supposed lack of proportionality here, according to the majority, is to compare or rather contrast this statute, the ADA, with the Voting Rights Act, which is a statute that was upheld as a valid exercise of Congress's enforcement power. So there we see a couple paragraphs on page 991 of why the Voting Rights Act met this test, although this test didn't exist when the Voting Rights Act cases were heard. But the idea there is that Congress provided a very robust set of materials that showed there was a long and persistent problem of voting rights discrimination, especially in certain states, in southern states. And the way they showed that was through statistics. They showed how many African Americans lived in some of these southern states versus what percent lived in other states that didn't have problems. And they showed the voting rates. And one conclusion is that there's no other explanation for the disparity between the number of registered voters and the number of people who actually vote than some sort of nefarious attempt to suppress the vote in some of those states. So the court says that areas where we've upheld valid enforcement clause legislation have been supported by lengthier or hardier records than Congress provided for the ADA. Right. So what conclusion do we draw when we see a Section 5 statute that lacks congruence and proportionality? So this is the conclusion I think that we can draw from Bernie as well as from the Garrett case. When the court finds that a statute lacks congruence and proportionality, what the majority here is really saying is that Congress has gone beyond its enforcement power and has impermissibly or unconstitutionally shifted into an interpreter of the Constitution. Right? So what the majority finds, and they say this at the very end of their opinion, over at the top, bottom page 991 to the top of page 992, right? Because the congruence and proportionality requirements are not met here, to uphold the Act's application to the states would allow Congress to rewrite the 14th Amendment law laid down by this court in Claiborne. Right? So just like the accusation in Birney was that Congress was trying to rewrite the law of the Free Exercise Clause from Oregon versus Smith in its RFRA statute, here the court seems to be making a similar conclusion. Congress is trying to rewrite the Equal Protection Clause jurisprudence that is represented in Claiborne by passing this ADA Title I statute. One more example to illustrate, or one more demonstration at how we might think of the congruence and proportionality test in a sort of graphic form. So one of the majority's concerns was that Congress didn't have any evidence that there was a pattern or a history of disability, of unconstitutional disability discrimination. So looking at this axis here, the evidence axis, going from less evidence to more evidence, right? When are we going to need more evidence? When is less evidence going to be sufficient? And this diagram shows that the amount of evidence needed goes up as, again, this is just dealing with equal protection law, as the harms that Congress says it is trying to remedy or prevent goes from strict scrutiny or suspect classes to rational basis scrutiny or non-suspect classes. So if Congress was trying to prohibit race discrimination, it would need less evidence than if it was trying to prohibit gender discrimination, than if it was trying to prohibit disability discrimination. Why is that? Because it's under almost no circumstances can a state engage in race discrimination, and in most cases, so long as there's a rational basis, can a state engage in non-suspect class discrimination. So this is one way to think about what the court is doing in that first section of that first part of Section 3, where it's talking about the evidence. And one thing, I don't have any slide on Justice Kennedy's concurring opinion. That's on page 992, 993. What sort of evidence? So Kennedy agrees with the majority. He joins the majority opinion, but he talks about a specific type of evidence that he would look to find ongoing disability discrimination. And he talks about evidence of cases filed. And Kennedy says that there just isn't that much evidence that people have been filing disability discrimination claims. And maybe if he saw more of those, he would believe that this was a problem. What about proportionality? So again, here along the x-axis, we have the type of remedy that Congress is imposing. So is it merely a reading here, is it a remedy that's closely tied to the constitutional violation, or is it a prophylactic remedy? In other words, is it a remedy that is doing more, is it addressing more conduct than simply the conduct that's prohibited by Section 1? Right? So a prophylactic remedy would be something like saying no literacy tests in voting, with the goal to prohibit racial discrimination in voting. Why is that prophylactic? That's prophylactic because literacy tests are not in and of themselves unconstitutional. But in order to get at the the problem that is a constitutional problem, which is racial discrimination in voting. You eliminate something or you cover your bases more than just the actual problem itself. So when and then the other axis, the y-axis here, is the evidence side of it. Less evidence of persistent violations, more evidence of persistent violations. So in order to really step outside of remedying what is prohibited by the Equal Protection Clause and starting to prohibit other things, you're going to need more evidence of persistent violations. Right. So the broader your legislation, the more evidence you're going to need of persistent violations, because at that point you could say there are so many violations, the discrimination is everywhere you look. To get at it, we're going to need a piece of legislation that covers a lot of territory, as opposed to if you have if you have a statute that is narrower, that only addresses really a very minor problem that you see, then you're going to need less evidence of a widespread problem. Right. So I think these two charts make quite a lot of sense. Study them closely, because I think if they don't immediately make sense to you, they will, and I think they help to explain a lot here. All right, what does Justice Breyer say in his dissent? We have a fairly lengthy excerpt of Justice Breyer's dissent. So Justice Breyer's main criticism is that the court demands too much of Congress. And the court demands too much of Congress without any real constitutional basis for those demands at all. So start off with this first point, that Section 5 historically has been interpreted as a necessary and proper clause. Right? If that's the case, then Congress should be given all of that deference that Chief Justice Marshall gave to Congress so many years ago. Congress should be able to make reasonable assumptions from all of the evidence it amassed, right? So Congress amassed this widespread evidence of disability discrimination, as Justice Breyer says in the middle of page 994. There is no particular reason to believe that they, that is the states, are immune from the stereotypic assumptions and pattern of purposeful unequal treatment that Congress has found prevalent. And one of Justice Breyer's main critiques of the majority opinion is this unwillingness to accept the evidence that Congress did have, or its very dismissive treatment of the massive evidence that Congress did have. Because according to Justice Breyer, the court only seems willing to accept instances of disability discrimination that could be proven in court. So when Chief Justice Rehnquist was reviewing the briefs and the examples of alleged state discrimination against the disabled, remember Rehnquist's response was, but these instances, they might be instances of poor treatment of disabled people, but they're not instances of unconstitutionally poor treatment. And Justice Breyer's response is, we've never required Congress to essentially make out court cases, meet standards of proof, meet burdens of proof in their evidence. Instead, what Breyer says, what the court seems to be trying to do is to treat the legislature as a court of law. Page 995, the first paragraph up there, Justice Breyer says, a legislature is not a court. In reviewing Section 5 legislation, we never required the sort of extensive investigation of each piece of evidence that the court appears to contemplate, right? So in order for the majority to credit those instances from the University of, going back to that, the University of South Dakota, the University of North Carolina, the Kansas Department of Transportation, it's almost as though the majority wants a full-blown investigation into each and every one of those instances. And we know that the majority talks about how many millions of disabled Americans there are and how many millions of people are employed. So if it wants a large mass in order to prove a pattern and a history of discrimination, that would be asking for an almost impossible amount of work. So that's one of Justice Breyer's critiques. And then he says, he says much the same on page 996. He says, Part 2 of the opinion, to hold Congress to a strict judicially created evidentiary standard, particularly in respect to lack of justification, is one of the problems that he finds here. Imposing this special burden upon Congress, the court fails to find in the legislative record sufficient indication that Congress has negatived the presumption. So his critique here is in the court seeming to reverse the usual presumptions of constitutionality that we give to Congress. And as he says in the next paragraph, the problem with the court's approach is that neither the burden of proof that favors states nor any other rule of restraint applicable to judges applies to Congress when it exercises its Section 5 powers. And his conclusion, therefore, on page 997, he says, to apply a rule designed to restrict courts as if it restricted Congress's legislative power is to stand the underlying principle, a principle of judicial restraint, on its head. So what does Justice Breyer think is going on? Part 4 of his opinion near the end, page 998, he says the court is essentially acting like the pre-1937 court was acting. The court that caused Franklin Roosevelt to threaten the court packing plan. The court that, the line of cases that gets overturned in 1937. Why? Well, the court is imposing, according to Justice Breyer, these artificial non-textual burdens on an explicit power of Congress. So in the same way that the late 19th, early 20th century court started ignoring the McCulloch test for constitutionality of legislation, the court here is ignoring that same test in passing on Section 5 legislation. And sort of similarly with the justifications for those pre-1937 or Lochner-era cases, the justification seems to be states' rights here, although we have the added justification of separation of powers problems as well. So the last paragraph, Justice Breyer mentions the 11th Amendment and the interaction with the 14th Amendment. So think about the 11th Amendment here. What's going on is, remember, it's Justice Rehnquist who wrote Fitzpatrick versus Bitzer in the 1970s that held that the 14th Amendment allowed Congress to waive states' sovereign immunity. Is Rehnquist trying to make up for that? Is he trying to make it a nullity by saying, yes, Congress can waive states' sovereign immunity through exercises of its Section 5 power, but it's going to be very, very difficult for Congress to enact valid Section 5 legislation? Is the issue of sovereign immunity lurking under this opinion more than meets the eye, perhaps? Is the court talking about Section 5, but really thinking about the underlying 11th Amendment sovereign immunity issue? At least that's one thing to think about there. What happened to Garrett afterwards? The same book, the excerpt from which I sent to you last week about the Alden versus Maine case, has another interesting little entry on the Garrett case. It's written by a political scientist. His investigation is that Garrett never really recovered much of anything. Unlike the Alden case, where there was a union, a public employees union, that was able to organize politically to get Maine to pass some legislation. This author's conclusion was that the disabled have never been able to organize politically the way that the labor unions were, at least in response to the Alden case. And so there hasn't really been any movement on this front. So there hasn't been any response. Garrett retired without ever really receiving any money for the alleged wrong. All right. We have another case on this material for Wednesday, for tomorrow. It's the Nevada versus Hibbs case. And notice, also written by Justice Rehnquist, but the case, perhaps surprisingly, will come out the other way. So what is it that that causes the change? We'll have to look at that tomorrow.